you cannot be subjected to dismissal or detriment based on your age, because clearly it is discriminatory unless it's justified by law. Now, I also need to mention these provisions also extend to contract workers, aside from just permanent employees on a rolling contract. Now, partnerships and LLPs, I mean, obviously, the category, the people I'm speaking to today are not simply, well, I mean, our focus is not simply on work, because obviously, many of us here are looking for opportunities to getting back into partnership. As it stands, the law, based on a case that was determined about, I believe it was in August, Selden versus Clarkson, Wright and Jakes, wasn't very good news, because what the Court of Appeal decided was that a retirement age in partnership contracts is legal and not unlawful. And in fact, the judge made a statement, part of the judgment actually to the effect that the collegial principle, which essentially is that the dead man's shoes principle, which essentially is that a junior partner should be made to feel that, well, listen, in a couple of years' time, I've got a chance of actually getting into this position, so this old man should be made to leave, which essentially is what the judgment was. And we were certainly up in arms, and we are definitely taking up the point, and we are going to fight this. We're certainly going to be supporting the Equality and Human Rights Commission and actually pushing this case up to the Supreme Court. Now, a particular point also made in the judgment was the effect that people should be allowed to retire with dignity. And that was one of the, and which I found to be quite strange. This is obviously my personal view, because retirement with dignity, I mean, clearly it's a matter of choice. If you choose to retire, it's your choice. It should not be enforced upon you. And the question of dignity within retirement is a personal choice, not one that can be legislated upon or enforced. Now, that's Selden, Clarkson, Wright, Jakes. Now, the Equality Act also provides protection now for personal office holders. We're talking about clergymen, officers of the Crown, and members of trade bodies, but obviously that's not our focus today, so I just thought I'd put that in as a general point. Now, the third point being, what happens if you have been discriminated against? Or indeed, how do you know you've been discriminated against? It's a moot point. And I go back to the definition of direct and indirect discrimination. The key factors being, one, have you been treated less favorably than another person for the reason of your age? And these are things that you can determine by, obviously, oral communications, written communications, or inference. Furthermore, if we want to go into the realm of indirect discrimination, is there a policy in place that places you, based on your age, at a disadvantage with a comparator? And obviously the word comparator being somebody else who you can compare yourself to, or within the same scale, the same position, but who only differs from you on account of not possessing the characteristic which you have, i.e. age. Now, if these parameters can be established, even on a cursory level, then definitely you have a potential claim for discrimination. But then, rather than dashing off to the employment tribunal, which has, sole jurisdiction on matters with discrimination, the law, as it has evolved, has engendered a need for dispute resolution. And indeed, the ACAS guidelines, which most of us might be aware of, the Arbitration and Conciliation Service, ACAS, makes clear that it is advisable for an employee, and indeed employers, to seek resolution of disputes, be it in discrimination or indeed other matters such as unfair dismissal or constructive dismissal. But it encourages that internal resolution of the matters be pursued before a claim is filed at the tribunal. Now, there are procedural steps which are laid down by ACAS, which I will go into next. One, put your complaint in writing to your line manager or the manager. And then, of course, the employer is then obliged to arrange a meeting with you to discuss your grievance. And as one thing's for certain, the ACAS guidelines, I need to mention, are not, are purely guidelines. They do not have the force of law in the sense that it's not illegal not to follow them, or should I say it's not fatal not to follow them. But then one thing that's absolutely certain is that the ACAS guidelines give you a legal right to be accompanied to the meeting, and that's the only provision, the ACAS guidelines, that actually needs to be, that are enforceable at law. Now, after a meeting, the employer should respond to your grievance in writing, setting out the action to be taken, and if you're unhappy with the outcome, you appeal in writing. Now, just a bit of, should I say, a few suggestions as to preparation for grievance meetings. Keep a careful written record of dates and times of the events complained of and all the relevant facts in chronological order. But absolutely important, because these are things, because we're looking not just at the grievance meeting itself, but indeed at the final outcome being a tribunal claim if things are not settled. Carefully consider if any colleagues with whom you may be compared to show less favorable treatment. Because clearly the most important thing in a discrimination claim is the comparator. Because you cannot, for you to claim to have been discriminated against, you're saying essentially that you've been treated less favorably. For you to have been treated less favorably, there must be someone by whom you can compare yourself to say, well, listen, he is better off than I am. So carefully consider this, put it down, and if possible, see how much evidence you can gather. Speak to colleagues, any colleagues who may have witnessed the act complained of, who can possibly help in giving evidence, not just at the grievance meeting, but indeed at the tribunal, because that indeed is the end game. Study the responses from the persons against whom the grievance is raised, because oftentimes a person against whom a complaint is made is given an opportunity to respond. And if possible, study that carefully to prepare yourself in advance. Detail your complaint clearly, because one thing we certainly say is less is more, and keep it simple. Detail your complaint without going into emotive and indeed copious detail. State what has happened in basic terms. Write out the points that you want to deal with and have your notes with you before going in for the meeting. And also, if possible, request a note taker with you. As I said, present your points calmly in a professional tone, and indeed make sure that you're taking down very, very detailed notes of what's happening, aside from what the note taker might be taking at the meeting. And at the end of the meeting, ask to review the notes taken. Now, the employer has an obligation at law to reach a decision on your grievance very promptly. There is no set time by law, but then oftentimes the standard practice is, say, 14 to 21 days max. Now, you have the right to appeal if the grievance outcome is unsatisfactory. You could either do this in writing, or indeed, of course, it should be done in writing, and it could be at a meeting, or it could be determined in writing. That is a matter of choice, and also based on individual contracts. Now, clearly, no one wants to go to the tribunal, but indeed, if you have to, well, the tribunal has jurisdiction over matters of discrimination, and it doesn't close the door on settlement, because ACAS, as an organization, has an obligation, a legal obligation, to indeed pursue settlement between the parties as soon as a claim is filed at the tribunal. And indeed, we find that most claims are settled via these means. Now, the parties, of course, may agree a settlement amongst themselves, because clearly one thing that we do find is that employers do consider that the litigation risk of a tribunal claim is not indeed borne out by pursuing a matter simply on grounds of principle, as they say, because clearly, as I need to mention, costs are not awarded at the tribunal unless your conduct has been unreasonable. So clearly, an employer might consider, well, listen, if you have an iffy claim, they would probably have to fork out about £5,000 to £10,000 on legal fees, and if it's probably easier for them to pay out, say, about 3/4 of that amount, if settlement can be reached between the parties. Now, the tribunal hears evidence and makes a decision. Now, the monetary awards that the tribunal makes are under the main head of injury to feelings, because essentially the compensation for discrimination is the injury to your feelings for the conduct by which you are subjected to. Now, there are 3 bands upon which the award for injury to feelings is placed. The bottom band being £600 to £6,000 for less serious claims, indeed where the conduct of the employer is not so bad as to essentially, well, I won't say not so bad, but certainly not on a scale, is not as grievous as it might be. The middle band being £6,000 to £18,000, being for slightly more serious claims, but not what may be regarded as the most grievous and serious claims at law, and the top band being from between £18,000 and £30,000 for extremely bad conduct by your employer. Now, in addition to that, you could also pursue an award for injury to health, because sometimes discrimination often results in psychiatric injury, which can be pursued in the county courts, and you can also pursue an award for lost earnings, because clearly if you have been off work based on psychiatric injury, you're losing money, and that's a financial claim. You cannot make, apart from discrimination claims, you cannot make non-financial claims at the tribunal, and these are pursued at the county court. And also ancillary loss, such as the cost of finding a new job, and loss of pension rights, etc. Now, an award, if you obtain an award at the tribunal, enforcement is done by the county courts, as in the bailiffs of the county courts, and that's essentially, that really, in summary, is the process from concept of discrimination, indeed to enforcing your rights at a tribunal. Now, Age UK as an organization, we provide more detailed information on this, and obviously I'm quite limited by time, and indeed I probably have overrun my time, and I do apologize for that. But we have a lot of fact sheets, a number of fact sheets on our website, which provide more detailed guidance on your rights as an older person in the workplace, and indeed options open to you. And the website is ageuk.org.uk, and I'm sure I'll pass on our website details to the organizers, and please feel free to contact me should there be any questions that you have in more detail from this. That essentially is my presentation, and I hope it's been helpful. Thank you very much.